Hello, everybody. Welcome to the Excessive Energy Billing webinar hosted by the Potts Law Firm. My name is Adam Funk. I am the Chief Operating Officer of the firm. Today, we're going to be talking to you a little bit about the February 2021 winter weather event and its impact on the excessive energy bills that have been going out. A little bit about the Potts Law Firm first. We are a firm headquartered in Houston, Texas, with offices nationwide. We have offices in Dallas, Arkansas, and across the Midwest as well. We primarily focus on litigation matters. However, we also conduct corporate matters as well as transactional matters. We specialize in a number of different practice areas, including first-party insurance disputes, as well as eminent domain, as well as class actions, including deceptive trade practice acts. Today, we're going to talk to you a little bit about the Winter Storm Uri and its impact on energy billing practices across the state. This includes both the electricity bills that homeowners received, as well as businesses, as well as the natural gas bills that have been coming out as of late. We're also going to be providing you with a legislative update in the Texas legislature about bills that are currently in committee, in the Senate, in the House, and even at the governor's table, waiting for approval. Finally, we're going to talk to you about legal remedies that you and your clients may have relating to these excessive bills that have been coming out. Today, we have a panel of speakers, as you will see, starting with Derek Potts, the founder and national managing partner of the Potts Law Firm. Derek is the head of our complex litigation division. In addition to being a successful trial lawyer, Derek is an innovative thinker. He has come up with quite a number of unique different mass torts as well as class actions that involve complex litigation. This includes inverse condemnation cases that have come out against the Army Corps of Engineers relating to Hurricane Harvey, as well as most recently, the class action that was filed against Griddy Electric and Symmetry Energy for excessive billing. In addition, partner Ryan Fowler is also on the panel. Mr. Fowler is a board certified trial lawyer who is also part of the complex litigation division. Mr. Fowler has extensive experience in energy law. And finally, Senior Associate Batami Baskin is also a member of the complex litigation division who will be updating you on the legislature and the updates going on there. Everybody is currently muted at the moment. However, there is a function for you to be able to ask a question. If you look at the bottom of your screen and roll over, you will see the ability to ask that. That goes into a chat box for the panelists to be able to review and answer if they are able to. For that, I'm going to hand it over to Mr. Potts to begin the webinar. Thank you for your attendance.
Good afternoon, everybody. I've been handling complex litigations for going on 20 years now, but I've only had two in my career where I was actually involved in the catastrophe, and this is one of them. So obviously, for those of us who are, as lawyers handling these cases, most of us live in Houston, and we're also living it. Like most people, I lost power, I lost water, I had busted pipes. Fortunately, I had a fixed rate on my electricity, so I did not receive an exorbitant bill. But in terms of everything else, I'm a participant in this. Therefore, it really hits close to home for me and the law firm, and we're glad to be handling these cases. So let me talk first a little bit about the storm, the timeline, to kind of put everything we're going to talk about today into context. So Winter Storm Uri, as you know, it started off as an Arctic vortex that, if you remember the press reports, they were telling us the week before that it was coming. And that's important for purposes of what we're talking about today, because the companies knew what was going to happen. A few of the companies gave notice to their customers, but most did not, from what we've seen so far. But in any event, there was plenty of warning. If midweek before Uri came in on the night of February 14th, with the middle of the week before that, it was already being reported on the news that this was coming. Gritty, which we're going to talk about later, which is a lawsuit we're pursuing on behalf of all Texas consumers, is one of the providers that actually did tell their customer base that they might want to consider moving to another provider, because Gritty was a pure variable rate plan. And in fact, about 20,000 of their customers moved over before the storm hit. So the timeline you're looking at kind of breaks out when the critical time periods were. The storm came in on the night of the 14th. I think a lot of people lost power that night. We're out of power for several days with rolling blackouts, and then at the end of the week, it picked back up. Let's go to the next slide on the impact, the power impact. So this slide shows kind of how the blackouts rolled through Texas. So the timelines I was just talking about, if you look above, it has the date and the time. And so by Monday at 10 p.m., it looked like that was one of nearly the greatest outage. And then by Tuesday at 12:15, looks like it was even greater. But you can see in the dark purple, that's where Houston is. Up above that, you can see Dallas. 4.5 million people lost power during the storm. We know that at least 100 people died. We're not here to talk today about those cases, but we and other firms are also handling those cases where people basically died of hypothermia. And there's 100 or so that have been filed against various providers for those. And then $295 billion in damage, which is what a lot of this litigation is going to be about, is about who is going to pay for this. Is it going to be the government? Is it going to be the providers? Is it going to be the customers? Is it going to be individuals and businesses? That's what a lot of this litigation is going to be about, is how is that $295 billion in damage going to be shifted amongst all those parties? In fact, and that's what a lot of our lawsuits are about today. The next slide kind of shows you the effect that it had on utility prices. So the top box shows you how the price of electricity went up to over $9,000 a megawatt. And a lot of that was due to ERCOT. The light blue line shows you when it went up. What's interesting, we've all heard on the news, is that even as the grid came back online, that $9,000 per megawatt stayed that high for another 32 hours due to ERCOT. And we're going to talk later on today about there's some legislation trying to address that. But suffice to say that $9,000 rate caused billions of dollars in damages, which our lawsuits are seeking to recover. The second box is the effect on natural gas. We've been talking to customer after customer after customer that received exorbitant natural gas bills. This graph shows you how the price spiked on natural gas between the 12th, hitting its height on the 17th. And the exorbitant bills that companies and individuals received just in that time period really is beyond belief. And we'll talk about that also today as well.
Hello, my name is Batanya Baskin. We receive a lot of questions regarding the legislation relating to excessive bills. I'm here to talk about mainly the electricity legislation. There are 7 pieces, and I'll start with the one that's in the Senate right now, just because it's the lone Senate piece of legislation, and it's the one that addresses the 32 extra hours that the electricity grid was operating at the $9,000 cap. That is, an independent organization has said already that that's about $16 billion in extra money that was earned because they kept the cap on for so much longer. So that piece of legislation is SB 2142, and that's to issue a repricing of the grid. Now, as you can see from the bottom workflow chart, that it's not getting a lot of traction. And from what we've heard, that it's basically frozen past the Senate going into the House committee. So from all these pieces of legislation, we don't expect that we will receive a lot of relief, and it'll be a slow moving process through the bicameral legislature up to the governor's office. And you can then see our next, probably most important piece of legislation is HB 16, which is the second workflow chart. And that is right at the governor's desk to eliminate wholesale index rates. So that would be a gritty type of case that we've filed a class action again, is to eliminate any kind of providing of that type of index price. And that does specifically apply to brokers. Brokers cannot offer that anymore if it passes. It also addresses renewals when the fixed price ends and requires certain notice provisions. The rest of the legislation is sort of addressing the public outcry. For instance, HB 10, which is the first workflow chart, is stuck in the Senate Jurisprudence Committee. And that one would require ERCOT and PUC board members to have residency in Texas. You probably heard that they almost all resigned or effectively got fired after the case. And most of them were not residing in Texas, and most of them had no experience in the electricity or energy market. The rest of the House bills, 11, 12, and 13, deal with an emergency crisis alert system, a council to oversee the ERCOT board itself. And finally, 11 is to address winterization and also summerization issues in order for generators and other equipment to withstand inclement weather. So that's the basics of the legislative update. If you have any questions, all the legislation is available on the Texas Gov website. Thank you.
Okay, my name's Ryan Fowler. I'm going to take a little bit of time here to talk about what we've been doing and some of the legal remedies we're focusing on, which I think is what we're getting the most questions from brokers on. Specifically, these causes of action have really taken two lanes. One is the breach of contract side. That's why obviously we always ask to look at the contracts, to look at the terms. While there are some standard contracts out there, we're finding that a number of the providers have basically rewritten portions of those to define the ancillary charges and the pass-through amounts that are being passed on. So even though the spot market may have a definition, some of the other charges that customers are getting charged either don't have a definition or are being defined in a way that certainly doesn't make sense. The second avenue we've looked at really are facts related to how these deals were done and how the contracts were entered. Specifically, if you've read either one of the class actions that we filed, you'll notice that we have a Texas Deceptive Trade Practices Act allegation. That's a consumer law that businesses, small and mid-sized, can also use. And it's allowing us, we believe, not only to make a claim for a reduction potentially in these bills that are out there, but also an independent cause of action that can recover damages. And potentially has a trebling factor too for egregious conduct. It also includes a damage element of attorney's fees. So it allows a lot of small businesses or mid-sized businesses that come to us still proceed with these claims without, paying a bunch of money up front to an attorney.
I'm going to talk now a little bit more specifically about the lawsuits that we have filed. So the first case you probably heard about was Gritty. We filed it about a week after the storm. Gritty is a class action to represent all approximately 30,000 Gritty customers that all received exorbitant bills. Gritty had a lot of their customers on auto debit, and in a lot of situations, they were just sweeping people's bank accounts, charging their credit cards multiple times a day during the blackouts. And so we filed that class action about a week after the storm. Our client, Lisa Corey, who's what we call the class representative to represent all people in that situation. She normally had about a $200 electric bill, and over a span of that week, got charged $12,000. And we see that markup is about consistent across the board. We have clients with as much as $89,000 charged for 1 week of electricity through Griddy. And in that case, as Ryan mentioned, we're suing not only for people's money back that paid, elimination of bills, that outstanding bills, but other damages you can get, such as mental anguish for having to deal with Griddy swiping money out of their bank accounts. In addition, the Texas Attorney General joined the case, essentially filed its own lawsuit, mirroring a lot of our allegations, agreeing that Griddy had also engaged in deceptive trade practices by sending or by getting people to sign up to these variable rate contracts without warning them of the risks, warning them what could have happened, really only painting a rosy picture of how much money you're going to save and how reasonable your rate's going to be, but then never mention the possibility of the downside of these deals. And that under the law, when you're selling any service or product, you can't just give the positives. You got to show them the negatives. Griddy has since filed bankruptcy, like a lot of the providers are starting to do. That doesn't mean that the class action ends. It just moves to the court, the bankruptcy court. And so now the bankruptcy judge is overseeing what's going to be the liquidation of Griddy and litigation that's going to go on out of the bankruptcy. So on the gas side, we filed a natural gas class action against Symmetry. We filed that case in the Eastern District of Texas, which is Marshall, Texas, representing a company up there that is a wholesaler of roses. And that company, Certified Roses, received about a $240,000 gas bill for a week, which would normally be about $9,200. In that case, if you read our complaint, a new line item was created by Symmetry on their bill that had not existed before. They called it incremental supply costs. This phrase is not defined in the contract. And basically what they have attempted to do and are still attempting to do is they put in all the extra cost of the gas as an incremental supply cost. And our lawsuit alleges that breaches the contract with the customers. That was not the intent and not the proper reading of the contract. And so that case will be proceeding in Marshall, Texas. In addition to that, we're representing a lot of clients on an individual basis. So some clients may not want to file a lawsuit. They may not want to participate in the class action. They may want to have their own lawsuit. We're doing those cases as well. It is possible to try to negotiate on their behalf with the companies. I think we have a lot of credence now with the companies since they know we're proceeding in litigation against a major electric power retailer, and then also Symmetry. So it gives us some credence when we're negotiating with them. So lawsuits are not the only answer. It's also possible to negotiate to try to reduce their bills or eliminate their bills through negotiation, through the threat of litigation. In all these cases, we're paid on a contingent basis, which means we're not asking for any money from the customers. We're paid on our ability to get bills reduced and collect damages. And we're only paid if we win. And so there's really no risk in terms of owing us money in any form or fashion. If we don't recover, if we don't reduce their bills, they're not going to know us anything. We're looking at many other cases currently against many other providers. I think I can predict that there will be more and more of these cases filed by us and probably other lawyers as time goes by, because this looks to us to be a systemic problem. It looks to us, from looking at the contracts and talking to the customers and talking to the brokers, that none of the providers ever anticipated this happening. Therefore, it did not show up in their contracts. I can guarantee you the contracts going forward are going to be completely different, because they're going to put something in there to address the situation that was not in there before. But whenever you have a situation that occurs that was not anticipated when the contract was entered into, that does not mean that a party all of a sudden gets to remedy that by defining the contract around the new event. And that's what these lawsuits are about. They're trying to prevent that from happening, to prevent the providers from rewriting the contract and pass on 100% of the cost from the billions of dollars in damage to the customers. It's not fair, it's not right, and we think that justice will be served by the judges ultimately that are going to read the contracts, interpret the contracts, and we believe find that in these cases, the charges being passed on are wrongfully being done.
Okay, some of the legal hurdles that we've talked about, we've addressed them here already, but these are three of the big ones we're seeing. One's bankruptcy. Again, personally, our class action in Gritty is stuck in bankruptcy. We've seen 7 of the retail energy providers, at my count last week, that have filed bankruptcy. I expect to see more. We had some that made their payments through to ERCOT, but I suspect it'll show up on the short pay list. And obviously bankruptcy has its own procedures, different judges, there's different rules that have to be followed. Immunity issues. Currently I've gotten a lot of questions from brokers asking about, well, who's really to blame? Maybe is ERCOT or maybe the PUC for setting the price or allowing ERCOT to do it. So the PUC has its own appellate process, if you will. There's administrative hearings that have to be gone through. You can't turn around and sue the PUC. And then ERCOT right now has alleged that they have immunity as well as a governmental entity or a quasi-governmental entity. Currently, that's what we're seeing in cases that are on file. There's actually an older case that's before the Supreme Court of Texas trying to decide whether or not ERCOT can be sued, period. The older case is obviously something different than what we're talking about today, but if that immunity gets granted and as a governmental entity, you cannot sue them, the immunity would apply for our cases potentially, or any cases that deal with the billing. Liability apportionment. We're probably, if we get to the point of awarding damages, we're going to have some finger pointing. We're going to have some of these companies point to ERCOT, PUC, or ultimately even the generators. There's a lot of still fact discovery going on how that litigation will work. A lot of it's going to depend on who the provider was and what their agreements were with the generators and exactly what they were told and how that's regulated. So at this moment, there's no litigation ongoing with those generators, even though I have seen a couple of providers file directly against ultimately a generator. There's nothing that's come of that yet. We don't have any courts that have ruled on that, any judgments that have come out. So those are the legal hurdles we see from a global standpoint. Again, each contract's a little bit different. I know it's not our question and answer yet, I don't think, but I saw one pop up in the chat asking some questions about Mid-American. Definitely, I'm looking at cases, our firm is looking at cases for Mid-American. That question that was asked was specifically related to some of the charges, and obviously I can't give a legal opinion without looking at the contracts, exactly what those charges were, but that is a legal hurdle that's going to pop up in every case, is exactly how are the charges being done, what are we calling them, and then ultimately the contracts and how those terms are defined. So I want to make sure we're clear. Each one's a little bit different. That's why we're not covering the exact contract language here today, but it's definitely something we're looking at, multiple other providers, including Mid-American.
So right now, as far as we know, we're the only firm handling these cases, both natural gas and electricity. We're also handling cases involving first-party insurance. So a lot of structures were damaged by the storm. We have a whole division of lawyers that also does that. That's unrelated to billing, but we do those sorts of cases also. And when insurance companies do not pay for the cost of repairs the way they should, we bring a lawsuit under Texas law and can recover attorney's fees. So bear that in mind also. But with respect to the excessive billing cases, the procedure, if you or your client wants to have us review your case, there's a couple things we need. First of all, we need the contract between them and the provider. Second of all, we need to see their billings from before and after the storm. We prefer billings basically for 2021 because that'll show us the format that it was billed before, and then how the company is trying to increase the bill, whether they're creating new line items that didn't exist before. All of those things are very germane to us to analyze whether they're trying to breach the contract or breaching the contract by sending this new bill in this new format and charging the customers in new and different ways. We have a portal set up for that to be done very easily. So this page here shows the portal. All you do is go to www.potsenergy.com. It's got very easy to use instructions on how to upload those documents. Upload those documents free of charge. An attorney will review those and get back in touch with you and to give you our legal opinion on what the contract says under the law in Texas or any other state, what the remedies may be, and what our advice is, whether you should do nothing, try to negotiate a settlement, or try to go to court and seek relief there. Also, if you have any just general questions, the email address below, energy@potslaw.com, can take any questions you might have. And of course, you're free to call us at any time. We've been talking to brokers and customers of brokers pretty much nonstop for the last several months. And so we're happy to talk on the phone as well.
Thank you all. I do not see any other questions that haven't been answered at this time. So I think that's the end of our webinar here, unless any pop up. You can see a recording of this webinar on our YouTube channel, which you can find by just searching Potts Law Firm on YouTube. For any other questions, concerns, anything that you want to get in touch with us, please email us, call us. We're here 24/7.
Thank you.
Thank you, everybody.